oath of office. I know that we signed those forms prior to calling to order. Do we need to do anything special to acknowledge that?
I think you just did.
Okay. Moving on down, we'll take roll.
Foley.
Here.
Patel.
Here.
Pittman.
Here.
Schust.
Here.
And Yart.
Here. Okay, next item is election of chair. I'll open the floor for nominations. Well, we're going to do it again.
The code says that in May of every year that you elect a chair and a vice chair. And so you probably don't remember, but I said in our meeting that we had recently, we will do this again in May.
I'll move to appoint Eric as chair again.
I'll second.
I do accept, and thank you. Roll call, please.
Foley.
Yes.
Patel.
Yes.
Pittman.
Yes.
Schust.
Yes.
And Yart.
Yes. Next item is election of vice chair. I'll open the floor for nominations.
Nominating Ricky.
Second.
Motioned and seconded. Roll call, please.
Foley.
Yes.
Patel.
Yes.
Pittman.
Yes.
Schust.
Yes.
And Yart.
Yes. Okay. Now we have under business, first item, consideration of the consent agenda. Should I read the whole thing, or is that adequate?
That's fine.
Okay. And the only item under the consent agenda is approval of the minutes of the regular meeting, January 16, 2025. Has everybody had a chance to look over the?
Yes. Board member Foley sent over or told me there was a slight error in one of her votes. I put her down as both yes and no. I think on number 3, I have fixed that, so it's good.
Was it yes or no?
It was yes.
I'll entertain a motion on the consent agenda being item 1A, approve the minutes of last meeting.
I'll motion to approve.
Second.
Roll call, please.
Foley.
Yes.
Patel.
Yes.
Pittman.
Abstain.
Schust.
Yes.
And Yart.
Yes. Next item, consideration, appropriate action, items removed from consent agenda. There were none. Next item is the Board of Adjustment Training Workshop. Thursday.
Yes, thank you, Chair, and thank you all for being here. I asked, January 2025 was the first time we'd had a meeting in a couple of years, and I do not take it lightly that you agree to serve and that you continue to serve. It is a very important role at the city, and it's a very important role across the state. It is, we'll get into it in just a minute, but I want to say thank you personally. And so I had said, our code says that in May of every year that we would elect chair and vice chair. And so I just said to everyone in January, hey, do you want to meet again in May? We'll do this, and we'll actually have training. And this kind of gets it out there for the public too, if they ever are interested in serving or have questions, maybe that we'll answer some of them tonight. So this is the same training that we provided, I think about 3 years ago. And at that time, we did not have it in a open meeting, and we'll talk about that. It's also in your notes. We won't talk about that right now, but we had it with Teresa Nallen, our city attorney, and she did a lot of the, I think she basically did the presentation, and we did it in small groups so that there was no violation of the Open Meetings Act. So tonight, I just thought, well, we'll do our oath of office, we'll say thank you, and we'll do some more training. So I will also say, this is not in the PowerPoint, at the city of Jenks, I've been here 5 years now, a little over 5 years, and when you look at a zoning map for a city, you'll see commercial areas, residential areas, industrial areas, and other things. But then there are what you call special districts or overlays, and different communities call them different things. NCOG does not really use the same language that we do, so I always refer to the NCOG map, but I wouldn't necessarily call it a PUD, which is a planned unit development, the same thing as what they do. But regardless, NCOG is the zoning map that we use as when we say we're going to amend a zoning for a parcel for a specific zoning. And in the city of Jenks, I would say we're at 155 PUDs.
153 is the new one.
153. So we have 153 planned unit development documents. So those documents are adopted by ordinance, which means they are codified. They become the law for that piece of property. So here's our zoning code, which is codified. And then here's all of these exceptions to the zoning code in this document. And in a lot of communities, the Board of Adjustment is used all the time because the property owner comes in and has an issue, maybe they have a hardship or whatever, and they come to the Board of Adjustment to get relief. At the city of Jenks, we have primarily dealt with those types of requests through a major or minor amendment to the planned unit development, rather than having the code and then the PUD and then a zoning, and then a Board of Adjustment case on top of it. So it's a layer that's not necessarily required. State statute doesn't say, take everything about this to this board, take everything about that to this commission. It's not how it's worded. So we have handled most of that through the PUD process. And that is why you all do not have as many meetings as most communities. And you don't have as many meetings as previous planners have regulated. So planners can regulate a little bit differently. This is how I've interpreted it. I think it is the most straightforward way for the property owner. And that's what it boils down to, is the property owner and their rights. So that being said, I'll try to jump in. I am not going to go over this word for word. I say that, but then I almost always do. So we'll see how that goes. The other thing is there's a multiple case law in here, and that is Teresa's expertise. And I did not know what time it was. I should have set an alarm. I was just reading those case laws in detail, and I was like, oh, this is fun. And Brandon's like, we're waiting on you. I was like, oh, what time is it? So I'm not going to get into the case law. If you have read it and had a very specific question, feel free to ask. I know. I thought of you. I'm so sorry. But I know. If you have a very specific question because you read one and you want to ask it, I will be happy to answer it, or at least try to answer it. And if I can't, I will absolutely say, let's talk to Teresa. So with that being said, I think on page 5, and we put this into your packet as background information. It says, does the city need a Board of Adjustment? So most of the municipal, especially zoning powers, come from state statute, and it's Title 11. And then 44 is what you see here, 44-101. So starting in 43, I think it even goes to maybe 40. It starts talking about all the different parts of regulating a city from land use. And so this is where we get the Board of Adjustment, is state statute, Title 11. And it says the governing body of a municipality shall provide by ordinance for appointment of a Board of Adjustment. And we did that. We have our Unified Development Ordinance. It's chapter 16, talks about the Board of Adjustment, and we took it out. I don't know if you remember, but when we updated the UDO, we took it, it was in a couple of sections about the Board of Adjustment. We put it all in chapter 16. So the Board of Adjustment at the city of Jenks, and in most places, is 5 members. You are appointed for 3 years, and you're removable by cause, for cause, by the governing body, so that would be the council, upon written charges and after public hearing. And I have never been in a situation where that has ever happened, and I hope I never am. But it would also say that every year in May, the council has the option of whether or not they want to reappoint someone. So that would be different. You're not being removed for cause. Maybe you've served for 5 years and they think that there's some community members that are really eager to serve and they would like to give them the opportunity. So you could, in the future, anyone could, same with the planning commission, they're appointed, they're recommended by the council or by the mayor and then appointed by the council. So, God forbid we ever had to write someone up, that would be horrible. But, vacancies are filled for any unexpired terms. We had, Gina was on the Board of Adjustment and she left and went to Planning Commission. And that seat sat vacant for quite a while and then we had Ms. Schust. So you are a quasi judicial entity and I think that this is so important to remember. And, completely different from legislative. So the council is legislative, you are quasi judicial. And if you have any questions, please feel free to ask. I'll do my best to answer. So, it says here, the Board of Adjustment is an administrative board clothed in quasi judicial powers, and I think that's a really good way to put it. And the last little bubble there says that your role is to apply laws to specific facts. Your role is not to change the ordinances or establish policies for future application. And you all have always done a really great job every time we have had a case to really listen and apply the laws. And in your case, the law is generally whatever our code says, whether it's the zoning code or if there's some other piece that you're legislating, so to speak. So, any questions about that? I'll try to say that. Okay, quasi-judicial proceedings must follow basic standards of due process. And we talked about this many times. And in our Unified Development Ordinance, Chapter 16, and in the administrative proceedings in Section 9 is where all of this is established. So there has to be a proper notice, and that is determined through state statute and then again by ordinance. So we try to follow 100% state statute for zoning and other things, but we can be more restrictive. Isn't that right? We can be more restrictive. Make that statement, then I'm like questioning it. But anyway, we follow state statute the best we can. So for Board of Adjustment, I think there's a 10-day notice. Everyone within a 300-foot radius gets a notice in a letter form, and then a sign is put up at the property. And it says proper notice of hearing, and it's required that we provide everyone with an interest, and that's that 300-foot radius, and there's full disclosure to everyone of the facts being considered by the decision-making body. No ex parte contacts. So it's very important to remember when you do have a case, you're not allowed to go and talk to the neighbors of the case, or to even really, you shouldn't be talking to the applicant. You are more like a judge. And so full disclosure to everyone of the facts being considered by the decision-making body, an impartial decision maker free from bias and conflicts of interest. And another thing that's really important is not to pre-state your position on an issue. Well, first of all, if you haven't heard all the facts in the hearing, because you're the judge, we have 5 judges, and when someone's making a case, I might make a presentation and a recommendation, but there may be other facts that come forward from the applicant, from the neighbors. There could be information that you don't have. And so it's very important not to pre-state those positions, and it actually is a violation, I believe, of your of the open meetings. So decisions based on the evidence, not on political pressure, fears, stereotypes, or voiced opposition. So in a planning commission or a council meeting, those counselors are elected by the citizens of their city, and they represent those citizens and their interests. So when they make a decision, it can and often does have political pressure, and it does often take the form of, or is influenced by, the voices that show up and speak. But in this position, as a quasi-judicial body, you are not supposed to be taking that into account. You are here to collect the facts, make decisions based on the facts. And it says decisions cannot be based on stereotypes or fears, which may or may not have a basis in fact, but must be based upon actual evidence. And they cite a case of Volunteers for America. So, general guidelines for quasi-judicial, and this says listen carefully and confine your decisions to the evidence presented. State, if you learn something outside of the hearing, you need to state it on the record and give the applicant and objectors opportunity to respond. So that goes back to you, keeping your opinions to yourself, and if you do collect information, that you're not out interviewing people and things like that. It's very important that everybody has the same information at the same time for legal reasons. You can probably explain that even better than me. Do you have anything to add?
No.
Okay. Judge.
Great job.
Like a judge, you can never prejudge a case or make a statement about how you will vote in advance of the hearing. All the evidence in advance of the hearing, all the evidence produced. So we call the meeting, you have a case before you, there's a recommendation, there will be some facts, and based on those facts, staff will make the best, most educated recommendation, but it's still your job to sift through that recommendation in addition to the evidence presented at the case, and then decide the direction you would like to go. Again, no ex parte discussions about the merits of the case. Direct anyone who contacts you to staff and state you cannot comment. Like a judge, you should be prepared, be respectful of the process, and to each other, and to even to the audience. I know we've had some very challenging meetings that they've been very challenging and sometimes scary. So just trying to be respectful of public opinion and still being safe. I should put that in there, and be safe. Ethics, observe formalities and maintain order. And we also have the council rules. I probably should have brought those to you. And the council ethics code. Have you all seen those before? I can't remember if we gave them to you. I'll try to get those out to you in an email.
I do recall getting the social media guidance.
Okay, I think,
I
okay.
don't know about something broader.
Let me see if I can at least get y'all a link to that. And if for some reason you do have a conflict of interest, it's fine. It's not a big deal. You just need to, you can't sit and participate in a decision if you have a conflict of interest or an appearance of a conflict. So if it is, if you ever think that there's a conflict of interest. The Schust, last time, she was actually leasing from the property owner. In that case, she wasn't standing, she made it public, and she was able to go ahead and go through with the decision, but there's a process, and a lot of times if you ever doubt, you can always email me, and if I don't know for sure, or if I'm not 100%, I'll ask Teresa, our city attorney. Okay, Open Meetings Act. So this is often a hot topic in the public. All meetings are subject to Open Meetings Act, and by all meetings, we mean all public meetings. So if Brandon and I decide to have the planning book reading club, and we want to meet every Thursday, that is not subject to open meetings. There's no action taken, no decisions are being made. We're just a couple of nerds who want to talk about planning, and so we don't have meeting minutes. We don't submit those to anybody for review or approval, etc. And if someone makes a statement and it's highly controversial in our meeting, it just is what it is. Someone just made a statement that's highly controversial, and it had nothing to do with me and Brandon. We just wanted to talk about planning nerd stuff. Okay, it was just me. It was never Brandon. He had to come to the meeting, that's all. So in, it says basic meeting rules. The Board of Adjustment, I'll read the top part, shall be subject to the open meeting laws of the state, and all meeting deliberations and voting of the board shall be open to the public. It shall be held in a public at convenient times and places and provide advance notice of the time, place, and subject matter. And this is in our ordinance as well. Is there anything you want to add to that, Brandon?
No, that pretty much covers it.
I consider him the guru of Open Meetings Act, because he goes to a lot of conferences and they talk about open meetings, probably every conference, huh?
The Oklahoma ones.
The Oklahoma
It gets a
one.
less, every state has their own different guidelines, so the national conference is a little.
So, a meeting occurs when you're conducting business of a public body. So this again kind of explains the difference between me having a conversation about planning books versus you having a scheduled meeting. We know that an action is going to be taken, et cetera. Avoid quorum outside of the meetings, even by email, social media, and text. The one time that I do violate, well, let me start over. I do a pretty good job of always blind copying everyone in an email. I don't really send, well, I do send you all text, but I try to do it individually. When it can become a problem, it's not a problem for me, but it could catch you all off guard, is if we have a special meeting and I send you a calendar request. So they don't really allow you to blind copy people in a calendar request. So I could create a separate calendar request for each of you, but I usually don't. I put you all in the same calendar request. And in that moment, you could have conversations, and I don't think that has ever happened with us, but I'm just saying that would be a time when, because sometimes you can respond to a calendar request. So anyway, that would just be one time that it could happen.
So to make the point on that one, just either accept or deny the invite.
Yeah, don't accept it, deny it, and then if you have a comment, send me an email, but don't do anything with the calendar request. Thank you for that. If quorum exists, including, so phone calls, so if you have, and this is something, the Board of Adjustment, an affirmative action requires a vote of 3. That is state statute. So quorum is not based on the number of people present. Quorum is based, quorum is 3 out of 5. That is quorum, but the decision also has to be 3, not based on the number of people present. So if you have quorum at 3 only, then everybody has to approve in order to pass the request. If a quorum exists, again, we're talking about text, emails, etc. Another thing that sometimes people don't think about, and sometimes it happens, sometimes it doesn't, but that's side conversations while you're in a hearing. It's really important not to be whispering to your neighbor, because the whole point of an open meeting or a public hearing is so that everybody gets the same information at the same time. And sometimes it's necessary to be like, I don't know what page she's on or whatever, and of course you can whisper that. But if you keep whispering, I may be like, excuse me, you need to use your mic, or you need to make sure that you have the floor for whatever conversation that you're having. Very, very important. We try to really pay attention to that in Planning Commission and at Council, that there aren't any side conversations. It could possibly violate the Open Meetings Act, but also is just, it's rude sometimes.
And to go off further than that, don't text each other during the meeting. Tulsa got in a lot of trouble for that on multiple fronts, so just don't do it.
Yeah, I don't normally look at my phone during meetings, and then sometimes I'll be like, what in the world, why are you people texting me? I wasn't even, so don't look at your phone, try not to. If a meeting is going long, I think it's fine to either ask for a break so you can check your messages. Maybe you have someone at home that you know maybe starting to be a little worried or needs relief from, who knows why they need to get the help with the kids down or something. So don't hesitate to ask for the floor for a break or something like that, but really try not to have those other communications. In an open meetings, you can go to the next one. The voting has to be publicly cast and recorded. It cannot be done by phone or email. I think Brandon said they are working at the state level to maybe allow people to call in? Did you say that, or are we just thinking that would be a good idea?
There has been multiple attempts to change both the Open Records and Open Meetings Act. I think the Open Records Act will probably get a little bit of an overhaul. Well, overhaul's the wrong word. Slight updates on things. I don't recall anything being passed related to the Open Meetings Act as of right now. There was conversations to try to make. There's already statutes that allow for remote meeting for members to appear remotely. It is very complicated, and wherever you are has to be open to the public, and you have to say where you are. So unless you want to invite people into your homes, which you would have to, then I don't recommend that. We've never had to do that, but we don't recommend it anyway. But short answer, as of right now, no changes.
Did you have a comment?
No, I know that you can do a Zoom or a Teams meeting, but you do have to announce where you are and what time it is.
Yeah,
If
and-
you're coastal,
Yeah,
Eastern Standard Time, Central Standard Time, Mountain.
Yeah, then
It's intense, but you can do it.
yeah, the majority of the body has to still be present in the building or in the location, and then there are a bunch of other caveats to that too.
Yeah,
It's
but
really
not
not worth getting into.
It isn't.
You're probably more, just miss the meeting. It's fine.
Yeah, I think we have taken, can you go to the next slide? We have taken the position that you should be present to be included. Avoid polling and negotiating, beware of text messages and social media. Don't text, tweet, or Facebook Live during meetings. How awkward would that be if y'all started opening up your phone and Facebook Living? Whoa, here we are live at the riveting Board of Adjustment meeting. Okay, Open Meetings Act continued. Notice an agenda. Did you have a question? Okay, agendas must be worded in plain language, directly stating the purpose of the meeting. For, excuse me, for an annual notice, I have to get your calendar to the city clerk by December 15th. And for a regular meeting, the agenda has to be posted 24 hours in advance. It does not require background information. We do that as a courtesy to the public as often as possible. Rarely, but on occasion, we have not included the background information since I've been here. I just cannot get it right. I'm missing a piece of information. I don't want to put it out there publicly until whatever. And so it hasn't been included, but at least the agenda was posted so we could have the meeting. If you have a special meeting called, it's a 48-hour in advance. And if it's not clearly on the agenda, it cannot be discussed or decided. And this is one of the easiest ways to get off topic. And I think the burden of the chair, this is really complicated because they have a responsibility to kind of steer the conversation to stay on the agenda. So sometimes you have to be pushy, and sometimes you have to be forceful, and that does put a lot of pressure on the chair, I would say. Did you have a question? Okay. Executive session, this is more to do with city council. We won't really go into that. Civil implications, any action taken in willful violation of this act act shall be invalid. Criminal penalties, you can be fined a misdemeanor up to $500 and up to 1 year in jail, which I don't even see how, that's like a huge disparity, right? $500 or up to 1 year in jail. I feel like if you're gonna get a fine or jail, the fine should be a lot more than that. Just my thought. Open records, maybe $500 was a lot of money back in the day. Maybe it equaled a whole year in jail. I don't know. Open Records Act. So this is different from Open Meetings Act. So in general, unless a record falls within a statutory exception, it shall be open to any person for inspection. That includes emails, text messages, social media, receipts from any board or of members relating to the city and board business. So very important what you say in your text messages. How you say what you say in your text messages. If you put something on social media, what does your email say? I am citizen Susie, and I have the right to ask for your emails regarding open records. We'll just say I'm very curious about that, and what in the world has Ricky been talking about regarding open records. And so I send a little thing to the clerk and I say, I want every one of Ricky's text messages regarding open records or regarding, splash pads or whatever. So your text messages are subject to open records. Make sure that you, do not put things that would be uncomfortable for the whole world to know. Civil, now, with that being said, they're not gonna get your messages to your mother, or your brother, or your wife, whatever. It's just everything to do with the wording that they asked for. Yes, sir.
One second. I do have another event to get to at the high school for my
Ready to go.
daughter. So I'd like to turn this over to Ricky, Vice Chair and Acting Chair, for the remainder of the meeting. I believe we will still have quorum.
We sure do. Thank you,
And
Eric.
thank you, this is very informative. I've read the whole thing. And
Have a
see you
good
all next
evening.
time. You too.
Okay,
Can I make one comment? 'Cause
Yes, sir.
I think I'm reading into this, and I think it's kind of important too, if I'm reading this correctly. But even if we don't have a quorum and we're meeting privately to discuss meeting business or business appropriate for the Board of Adjustment, we would, if we're still communicating by
Mm-hmm.
text message or communicating about it, that's still open to the general public,
yes, sir.
even though it's not considered an open meeting.
It is best if you do not talk to your fellow board members or to the public or it's better if you do not talk to anyone when you get notice of a case. You can't help if you already heard about it on social media or something like that. That can't be helped. But the minute that you know this is coming to the Board of Adjustment, you have a responsibility for no you say ex parte? Communications, the end. Like, once you know that you're having a case, you really should not ethically talk to anyone else, even if it is not, quorum.
And even after you vote, even after the meeting, they still have the right to appeal to the district court, and so
Very good
those
point.
records are also still available to them.
Very good point. I hadn't thought of that, but that's an excellent point. Just because you, deny something, they have the authority and the right per state statute to appeal to district court. And now anything, your emails, your text messages, your conversations can be used in the district court case. So very important. I think that's a really good distinction to make. And it's something I probably haven't really said before, so I appreciate that a lot. Any more questions in that regard? Okay, the next one. This one's kind of hard to read. It basically says, you have the power per state statute, Title 11, and again, in this case, 44 through 104, and then also in the Jenks UDO 16-9-4, to hear and decide appeals if if it is alleged that there's an error in any order, requirement, decision, or determination made by an administrative official of the enforcement of any zoning ordinance. So if I tell someone something and they do not believe that I am accurate in my interpretation, they can appeal to the Board of Adjustment. And then it would be your responsibility to evaluate the law and the application of that law in that case and decide if, in fact, maybe there was an error made by the staff. Hear and decide special exceptions to the zoning ordinance to allow a use or specifically designated element associated with a use. I know home-based childcares are still a special exception in the code. It's the only one I can think of. We may have one or two other special exceptions, but that one I know for sure is still a special exception.
Isn't dispensaries,
No.
they're not?
Special exception.
I don't know.
I
Good
believe
question.
they are a special exception, I think it's a special exception, if they are trying to be a dispensary within a shopping center that is not fully marijuana based. Did I just speak gibberish?
No, is that in our, that's not in our use tables. He can look it up while we're talking. You also had are to authorize in specific cases a variance from the terms, standards, and criteria that pertain to an allowed category within the zoning district. And then here decide oil and gas applications or appeals, which I've never even had anyone come for that, so that would be interesting. So on the next page, it says the special exceptions and or variances may be allowed by the Board of Adjustment only after notice. That's a little bit of redundancy. A variance, this is important to note. A variance is an exception to a part of the zoning ordinance. And a variance is not a change in the zoning law. So you're not rewriting the law, you're not changing the law, you're simply saying this law creates a hardship and cannot be applied in this situation. So you're saying they do need a variance and we support that request. Let's go. 4 elements of a variance. It's all variance. You have to go by each one of these in the process of approving a variance. Can you change the slide? Number 1 is a strict application of the ordinance to the particular piece of property would create an unnecessary hardship. On the next one. And the next one. Thanks. Such conditions are peculiar to a particular piece of property involved. Relief, if granted, would not cause substantial detriment to the public good or impair the purposes and intents of the ordinance or the comprehensive plan. And I want to point out that the Board of Adjustment and state statute actually talks about the impact and the influence of the comprehensive plan, even talking about variances. So you're quasi judicial and yet you still take into account what does that comprehensive plan say. And I'm making that a point because there is state legislation that is trying to remove the authority of the comprehensive plan. And we always say the comprehensive plan is a guiding document, and that is true. But it is a very important guiding document, so much so that in the case for a variance, it is a consideration. What does the comp plan say? And it's the same with zoning law. What does the comprehensive plan say? So that's at the state. I don't know if it's made it out of committee, but it is definitely being kicked around. And it would deeply impact how communities and municipalities do their zoning. The variance, if granted, would be the minimum necessary to alleviate the hardship.
Just for clarification, nothing related to marijuana is a special exception. The only thing besides childcare I can see is outdoor activity operation in industrial zoning,
Okay.
along with outdoor storage.
Okay.
Thank you.
Thank you.
I have a question.
Yes.
Do you have the information about the bill?
Give
By
me,
chance?
give me 1 second.
Yeah, we can find it.
Okay, keep going, I'll find it.
Yep. Oh, and then the next slide is what is a hardship? An unnecessary hardship is found, and there are 4 different criteria. And I'm not going to go through all of those. I think we've hit it pretty good many times. Hardship results in the physical surroundings, shape, topography, or topographical conditions, and was not created or self-imposed. So I think a lot of times it's really important to note that the owner didn't seek to do the action and then ask for forgiveness. Maybe there was an oversight. Maybe they didn't have the right pin when they were measuring for their building, their footing, and et cetera. It happens. And then financial hardship alone is not sufficient, which I think that statement is a little softer than what the state statute says, because I thought state statute said that financial hardship is not a consideration. So I don't think that's wholly what it says, but I know, I was like, I'm pretty sure. So on page 22, it talks about a practical case, and like I said, I'm not going to go into these. Did you have a question about it? Anybody? Okay, I'm not going to go into these things.
Marcy,
Yes,
just
sir.
quickly, I found the email from LML. It is Senate Bill 647, Municipal Planning and Zoning. SB 647 would significantly undermine local control and limits a municipality's ability to determine what is best for growth and future development.
I just
Yeah.
want to know where it is on
Yeah,
the floor.
yeah, SB 647.
2 weeks from now. Most of my day.
Yeah, for sure.
I think these elements are incredibly helpful. Are they usually available to us before meetings or during meetings? They specific, like for instance, what is a hardship?
Yes, I usually put it in the actual staff report,
Okay,
where I will say, and I tell the applicant, generally, you're gonna have to prove to me every one of these criteria. And so sometimes they write there, and I'd be like, oh, that's not a hardship. But then other times I can help them, we can talk through it and maybe get a better understanding of what they're trying to articulate, if I really see that they do have a hardship. But it's very important, and you really can't make a decision without having checked all of those.
all right. In your staff reports, do you put all these in there? Or do you just pinpoint one or two and you say?
No,
these are
all of them.
Okay,
Yep,
all right.
absolutely.
That's really
It's been-
helpful.
It's been a really long time.
Sorry.
I know, we haven't had a meeting in so long. So, but yes, I think I try really hard to put our code into my staff reports. So for planning commission, same thing. If they're reviewing a plat, then I put, this is exactly what I reviewed, and you can go through it yourself, see if I missed something, because it's highly possible I did, but this is what I was looking for. And it also tells the public, like, this is what we're looking for. And especially when you're presenting or providing that background information in advance of the meeting, then the public also knows what criteria you're using to make your decision. Instead of, it's not ad hoc. You actually have a set of very rigid guidelines that allow you to make your decisions.
Thank you.
I am very uncomfortable with Board of Adjustment. Like, I don't feel like it's my superpower. Some people love it and really feel like they excel at it. But I guess I'm just so intimidated that, well, if we do it wrong, they can appeal to district court. It just makes me really nervous. So I'm usually pretty cautious. A lot of times I will even call you all in advance and let you know that something's coming so that you can be thinking along those lines. But it's hard for me to feel like I don't have that hesitation on other zoning matters, but when it comes to variances, it's very serious to me, and I try really hard to make sure that we make a decision based on what are our state ordinances and or state statutes, and what are our local ordinances, and did we meet all of those criteria. It's also a reason why you don't get very many cases, is because I will tell an applicant up front, you don't qualify. You have a request, not a hardship. Like, just because you really, 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 really super want a pool in your backyard does not mean that you can get a variance. So, let's see. On page 25, it talks about practice case, a Supreme Court holding Banks versus City of Bethany. And this was 1975. Again, I'm not going to go into it. They were very interesting. It does point out that it showed that if relief were granted in this particular case, it wouldn't violate the intent of the comprehensive plan. So again, keeping that in the back of your head and your mind when you hear of zoning cases, when you hear of Board of Adjustment cases, when something's going to the city council, what does that comprehensive plan say? What was that recommendation that was adopted by resolution by the city officials? So I think it's really important. A special exception, we just talked about that a little bit out of order. So this is found in 16-9-6. And we update the Unified Development Ordinance probably about maybe once a year, sometimes twice a year. So we adopted it officially in 2025, so we've had about 4 updates, I think. And if you ever think, and I would appreciate your input, if you ever think when you're just really gung-ho about reading the zoning code, and think you just can't do anything else until you read it one more time, if you look through those use charts and you feel like, well, this probably should be a Board of Adjustment case, not, Planning Commission and City Council, I'm always open to amending it to bring it to the Board of Adjustment as a special exception. So a special exception is, when you hear and decide special exceptions to the zoning ordinance to allow a use or a specifically designated element associated with the use which is not permitted by right in a particular district because of the potential adverse effect, but which, if controlled in the particular circumstance as to its relationship to the neighborhood and to the general welfare, may be permitted by the Board of Adjustment. And I think I wrote down automotive uses as an example. So in most cases, automotive, a paint and an auto body shop, in most cases, is still regulated in the zoning code to industrial areas. But technology now is such that it probably could go in a commercial heavy zoning because they have the ability to capture the paint fumes, and they have all of this new technology. So it's possible that there could be evidence that it would not have an adverse impact and could in fact be allowed in a more commercial area than in an industrial area. And you see a lot of automotive shops in commercial areas, but often they don't allow for automotive painting. So that was one that I thought of when I was going through there. So for a special exception, the criteria that you ask yourself, will it be in harmony with the spirit of the UDO and the governing zoning district? And number 2, will not be injurious to the neighborhood or otherwise detrimental to the public welfare. And you should specifically find that each of the criteria is present to grant that special exception. So this is very similar to a hardship to a variance, where you have 4 criteria that you're saying yes, 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 yes. For a special exception, there are 2 criteria that are paramount. And then the difference between a variance and a special exception, I think this is really well stated. The difference is that a variance is an excused violation and a special exception is a conditional permitted use. So to get a variance, you had to have broken the law already. But a special exception is asking permission with conditions to do a use. So, let's see. This is a practice case. I think that's really it. So probably went kind of fast through that, but do you all have any other questions or anything? I really appreciate you very, very much. I appreciate Brandon too, because he's a real trooper for that book club.
I want it noted that Marseille listens to books. She doesn't read them.
That's not on the agenda. Ricky, do you want to close us out?
Yes, any other business planning updates?
I will say that we're in the middle of our downtown master plan public engagement portion. I set up 6 public opportunities. We had 3 people, including one was a news person at the first meeting yesterday at lunch. And then this morning at 7:30, we had coffee and muffins and fruit. And 10 people showed up, and they were people I'd never met before. And so that was very exciting for me. And I was very surprised by their input. Very interesting, very engaging. And so there are 4 more opportunities. And then the consultants will be at the Food Truck Festival. And after that, we'll probably be wrapping things up.
The consultants from the previous meetings, like I came to one
Beck
at the high.
Design. Yeah.
Yeah.
If not anything else, do we have a motion to adjourn?
You don't need a motion, you can just adjourn.
Meeting adjourned.